Introduction to Notary Public Role. A notary public serves as an impartial witness to the signing of important documents, verifying the identity of the signer and ensuring they sign willingly. This role is critical in preventing fraud and maintaining the integrity of legal and financial transactions. Notaries are public officials appointed by a state authority, typically the Secretary of State, to perform specific notarial acts. Their primary duty is to protect the public by ensuring the authenticity of signatures and the veracity of documents. Understanding the foundational principles of this role is paramount for any aspiring notary professional. The authority and responsibilities of a notary are strictly defined by state law, which varies significantly from one jurisdiction to another. Therefore, a deep dive into specific state regulations is essential for proper practice. The notary's presence adds a layer of trust and legal validity to documents, making them enforceable in courts of law. Common documents requiring notarization include real estate deeds, powers of attorney, affidavits, and loan documents. Notaries must possess a strong sense of ethics, attention to detail, and a commitment to impartiality. They are not legal advisors and must refrain from offering legal advice or drafting documents. The public relies on notaries to uphold the law and perform their duties with integrity and precision, safeguarding against potential legal disputes and financial losses. Notary public qualifications. Each state sets specific eligibility requirements for individuals seeking to become a notary public. These qualifications typically include age, residency, and citizenship status. Most states require applicants to be at least 18 years old and a legal resident of the state in which they are applying. Some states may also require U.S. citizenship or legal permanent residency. It is crucial for prospective notaries to thoroughly review their state-specific statutes before applying, as these requirements are strictly enforced. Failure to meet any of these basic qualifications will result in the rejection of a notary application. These prerequisites ensure that notaries are mature, established members of the community, capable of understanding and upholding their significant legal responsibilities. Beyond basic demographic requirements, many states mandate that applicants demonstrate a certain level of education or pass a notary exam. This ensures that notaries possess the necessary knowledge of notarial law and procedures. Some states require a clean criminal record, disqualifying individuals with felony convictions or certain misdemeanors. A background check is often a standard part of the application process to verify this. Furthermore, applicants must typically be able to read, write, and understand English, as notarial acts often involve complex legal terminology. These stringent qualifications are designed to maintain the integrity and trustworthiness of the notary public system. Understanding notary commissioning process. The commissioning process is the formal procedure by which an individual becomes an authorized notary public in their state. This typically begins with submitting a detailed application to the state's commissioning authority, often the Secretary of State's office. The application requires personal information, confirmation of eligibility, and sometimes references. After submitting the application, applicants may need to complete a state-mandated training course or pass an examination to demonstrate their knowledge of notary law. This step ensures that all commissioned notaries are well-versed in their duties and the legal framework governing their actions. The process is designed to be thorough, safeguarding the public from unqualified individuals. Upon successful completion of any required training or examination, and approval of the application, the state will issue a notary commission. This commission is a legal document granting the individual the authority to perform notarial acts. Before exercising this authority, the newly commissioned notary must usually take an oath of office and file it with the appropriate county clerk or state office. They must also obtain an official notary seal and a notary journal, which are essential tools for performing their duties legally and effectively. The entire process, from application to receiving the commission, can take several weeks or even months, depending on the state's administrative efficiency. Notary bond and E&O insurance. A notary bond is a surety bond required by most states to protect the public from financial harm caused by a notary's errors or misconduct. This bond is not insurance for the notary. Rather, it guarantees that if a notary causes financial damage due to negligence or intentional wrongdoing, the injured party can file a claim against the bond. The bond amount varies by state, typically ranging from a few thousand to tens of thousands of dollars. Notaries must obtain and maintain this bond throughout their commission period. It acts as a financial safeguard, ensuring that victims of notary errors have a means of recourse. Without a valid bond, a notary cannot legally perform their duties, underscoring its critical importance. While a notary bond protects the public, errors and omissions (E&O) insurance protects the notary themselves. E&O insurance covers legal expenses and damages if a notary is sued for an honest mistake or oversight made during a notarial act. Unlike the bond, E&O insurance is generally optional but highly recommended for all notaries. It provides peace of mind and financial protection against potential lawsuits, which can be costly even if the notary is ultimately found not liable. This insurance is particularly vital for notaries who perform a high volume of transactions or handle complex documents, as it mitigates personal financial risk. Investing in E&O insurance is a prudent business decision for any professional notary. Notary journal requirements. Maintaining a notary journal is a critical requirement in many states, serving as a detailed record of every notarial act performed. The journal provides an invaluable audit trail, documenting the date, time, type of act, and identity of the signer. It is a vital tool for preventing fraud and defending against potential legal challenges. States often specify the format of the journal, whether it must be a bound book with numbered pages or an electronic record. Adhering to these specific requirements is not optional. It is a fundamental duty of the notary public. Proper journal keeping protects both the notary and the public by providing clear evidence of due diligence. Each journal entry typically requires specific information, including the signer's name, address, and how their identity was verified. Notaries must record the type of identification presented, such as a driver's license or passport, and its issuing authority. The signer's signature is also usually required in the journal itself. Some states even mandate recording the fee charged for the notarial act. It is imperative that notaries never allow a signer to pre-sign the journal or sign on behalf of another person. The journal must be kept secure and confidential, accessible only to the notary or authorized legal entities. Understanding and meticulously following these journal requirements is a cornerstone of ethical and legal notary practice. Official notary seal and stamp. Every notary public is required to possess an official seal or stamp, which is used to authenticate notarial acts. The seal serves as a unique identifier for the notary and provides visual proof that the document has been properly notarized. State laws dictate the specific design, size, and information that must be included on the seal. This typically includes the notary's name, the words notary public, the state of commissioning, and the notary's commission expiration date. Some states also require a commission number or county of commissioning. The seal must be clear, legible, and capable of being reproduced on paper, ensuring its legal validity. It is a fundamental tool that signifies the official capacity of the notary. Notaries must exercise extreme care in safeguarding their official seal or stamp. It is considered an instrument of public trust and must be kept secure at all times to prevent unauthorized use. Misuse of a notary seal can lead to severe legal penalties, including fines, suspension, or revocation of the notary commission. Notaries should never allow another person to use their seal, even if they are also a notary. Upon resignation, expiration, or revocation of a commission, the notary is typically required to destroy or surrender their seal to the commissioning authority. Understanding and adhering to these regulations regarding the seal is crucial for maintaining legal compliance and professional integrity. Identifying signers, best practices. Properly identifying the signer is arguably the most critical duty of a notary public, as it directly prevents fraud and ensures the integrity of the notarial act. Notaries must verify the identity of the individual appearing before them using reliable forms of identification. State laws specify acceptable forms of ID, which commonly include current government-issued identification cards with a photograph and signature, such as a driver's license, state ID card, or passport. Notaries must carefully examine the ID for any signs of alteration or tampering. The name on the ID must match the name on the document being notarized. This meticulous verification process is the cornerstone of a notary's public protection role. Beyond examining physical identification, some states allow for identification through credible identifying witnesses. A credible witness is an individual known to both the notary and the signer, who can swear or affirm to the signer's identity. This method is typically used when the signer does not possess acceptable forms of photo identification. However, notaries must be cautious and ensure the witness is truly credible and impartial. It is crucial to document the method of identification used in the notary journal for every notarial act. Never rely solely on personal acquaintance or a mere statement of identity. Always follow state-mandated procedures rigorously to avoid potential liability and uphold the public trust. Administering oaths and affirmations. Administering an oath or affirmation is a fundamental notarial act where the signer solemnly swears or declares that the contents of a document are true. An oath is a solemn pledge invoking a deity or sacred entity, while an affirmation is a solemn declaration made without reference to a deity, suitable for those with religious objections or no religious belief. The notary must ensure the signer understands the gravity of their declaration and is doing so voluntarily. This act is crucial for documents like affidavits and depositions, where the truthfulness of statements is paramount. The notary's role is to witness the act of swearing or affirming, not to verify the truth of the statements themselves. It is a procedural verification, not a factual one. To properly administer an oath or affirmation, the notary must place the signer under oath by asking a specific question, such as, "Do you solemnly swear or affirm that the statements contained in this document are true and correct to the best of your knowledge and belief, so help you God?" For an oath, or "Do you solemnly affirm that the statements contained in this document are true and correct to the best of your knowledge and belief?" For an affirmation, the signer must respond audibly and affirmatively, typically with "I do" or "yes." The notary then completes the notarial certificate, indicating that the oath or affirmation was administered. This formal process ensures legal enforceability and underscores the seriousness of the signer's declaration, making them legally accountable for their statements. Taking acknowledgements. An acknowledgement is a notarial act where a signer declares to the notary that they have voluntarily signed a document. The notary certifies that the signer personally appeared before them, was identified, and acknowledged their signature on the document. This act is commonly used for real estate transactions, powers of attorney, and other documents where the signer's free will in signing is crucial. The notary's role is not to verify the truthfulness of the document's contents, but solely to confirm the identity of the signer and their voluntary act of signing. It provides assurance that the signature was not forged or coerced, adding a layer of legal protection. To perform an acknowledgement, the notary must first ensure the signer is physically present. Then, the notary verifies the signer's identity, using acceptable forms of identification, as mandated by state law. After confirming identity, the notary asks the signer if they willingly signed the document. Once the signer affirms this, the notary completes the acknowledgement certificate, which is typically pre-printed on the document or attached as a loose certificate. This certificate includes the notary's signature, seal, and commission expiration date. It is essential that the notary never pre-fills or pre-signs the acknowledgement certificate before the signer's appearance, as this constitutes serious misconduct. Certifying copy documents. Certifying a copy of a document is a notarial act where the notary attests that a copy of an original document is a true, exact, and complete reproduction. This act is not permitted in all states, and some states only allow it for specific types of documents, such as powers of attorney or journal entries. It is crucial for notaries to understand their state's laws regarding copy certification before performing this act. Generally, the notary must personally make the copy or supervise the copying process to ensure its authenticity. The original document must be presented to the notary, and they must verify that the copy is identical to the original. This act provides legal assurance that the copy holds the same weight as the original for certain purposes. When performing a copy certification, the notary typically attaches a specific notarial certificate that states they have certified the copy. This certificate will include the notary's signature, seal, and commission expiration date. Notaries must never certify copies of vital records, such as birth certificates, death certificates, or marriage licenses, as these are typically handled by the issuing government agency. Similarly, federal documents like U.S. passports or naturalization certificates cannot be copy certified by a notary. It is paramount to adhere strictly to state guidelines and prohibitions to avoid legal repercussions and maintain the integrity of the notary's commission. Always consult state notary handbooks for precise instructions on copy certification. Executing jurats. A jurat is a notarial act where the signer swears or affirms the truthfulness of the contents of a document directly to the notary, and then signs the document in the notary's presence. This act is distinct from an acknowledgement because it involves an oath or affirmation regarding the document's truthfulness. Jurats are commonly required for affidavits, depositions, and other sworn statements where the signer attests to the factual accuracy of the document's content. The notary's role is to administer the oath or affirmation and witness the signing, ensuring the signer understands the legal implications of their sworn statement. It is a critical step in establishing the legal validity of sworn testimony. To properly execute a jurat, the notary must first administer an oath or affirmation to the signer, ensuring they understand they are swearing to the truth of the document's contents. The signer must respond audibly and affirmatively. Immediately after the oath or affirmation, the signer must sign the document in the notary's direct presence. The notary then completes the jurat certificate, which typically states that the document was subscribed and sworn to or affirmed before me. This certificate includes the notary's signature, seal, and commission expiration date. It is paramount that the notary never notarizes a document with a jurat if the signer has already signed it prior to appearing before the notary, as this violates the core requirement of witnessing the signature under oath. Prohibited notarial acts. Notaries public are public officials with specific, limited authority, and certain actions are strictly prohibited by state law. Engaging in prohibited acts can lead to severe penalties, including fines, commission suspension, or even criminal charges. One of the most critical prohibitions is performing a notarial act for a document in which the notary has a direct financial or beneficial interest. This ensures impartiality and prevents conflicts of interest. Notaries also cannot notarize their own signature or a document where they are a party. Understanding these limitations is paramount to ethical and legal practice, as even unintentional violations can have serious consequences. Other common prohibited acts include notarizing a document if the signer is not physically present before the notary, which is known as a false notarization. Notaries cannot notarize a document if the signer is not identified through state-approved methods. They are also prohibited from providing legal advice or drafting legal documents, as this constitutes the unauthorized practice of law. Furthermore, notarizing incomplete documents or documents with blank spaces is generally forbidden, as it creates opportunities for fraud. Notaries must never pre-sign or pre-stamp a notarial certificate. Adhering to these prohibitions is essential for maintaining the integrity of the notary profession and protecting the public trust, requiring constant vigilance and adherence to state statutes. Notary fees and state regulations. States establish maximum fees that notaries public can charge for performing specific notarial acts. These fee schedules are designed to prevent overcharging and ensure fair access to notary services for the public. Notaries are legally bound to adhere to these maximum fee limits and cannot charge more than what is prescribed by state law. Some states may also specify additional fees for travel or other services, but these must also comply with state regulations. It is crucial for notaries to be fully aware of their state's current fee schedule and to communicate these fees clearly to clients before performing any services. Transparency in fee disclosure builds trust and avoids disputes. While states set maximum fees, notaries are generally permitted to charge less than the maximum amount or even offer services for free. However, any fees charged must be consistent and applied fairly to all clients. Notaries should never discriminate in their fee structure. It is also important to note that the fee charged is for the notarial act itself, not for the outcome or success of the document. Notaries must provide an itemized receipt if requested by the client, detailing the services rendered and the fees charged. Understanding and strictly following state regulations regarding fees is essential for ethical business practice and avoiding potential complaints or legal issues. Advertising notary services. When advertising notary services, notaries public must adhere to strict state guidelines to ensure accuracy and avoid misleading the public. Many states have specific rules about what can and cannot be included in advertisements, particularly concerning legal advice. Notaries are generally prohibited from using terms that imply they are attorneys or can offer legal services, such as legal document preparer or legal services. The advertising must clearly state that the notary is not an attorney and cannot give legal advice. This distinction is crucial to prevent the unauthorized practice of law and protect consumers. Transparency in advertising is a legal and ethical imperative for all notaries. Effective advertising should clearly state the services offered, such as mobile notary, loan signing agent, or general notary work. Notaries can list their fees, availability, and contact information. When advertising in multiple languages, notaries must ensure that all disclaimers regarding legal advice are also translated accurately. Some states require specific disclaimers to be prominently displayed in all advertisements. Utilizing professional branding, a clear website, and social media can help reach a wider client base. However, every advertising channel must comply with state regulations, ensuring that the public receives accurate information about the scope and limitations of notary services. Regular review of state guidelines is essential for compliant marketing. Maintaining impartiality and ethics. Impartiality is the cornerstone of the notary public's role, requiring them to act without bias or personal interest in any notarial act. A notary must treat all signers equally, regardless of their background, beliefs, or relationship to the notary. This means refraining from notarializing documents for family members or anyone with whom the notary has a direct financial or beneficial interest. Maintaining strict neutrality ensures that the notarial act is perceived as trustworthy and legally sound. Any perceived bias can undermine the integrity of the document and the notary's commission. Ethical conduct is not merely a suggestion, it is a fundamental requirement of the office, safeguarding the public trust. Ethical notarial practice extends beyond impartiality to include honesty, integrity, and diligence in all duties. Notaries must never mislead signers, offer legal advice, or perform acts outside their authority. They must also protect the privacy of signers and the confidentiality of documents, never disclosing information learned during a notarial act unless legally compelled. Continuing education and staying informed about changes in state notary law are also ethical responsibilities. By upholding the highest ethical standards, notaries contribute to the reliability of legal processes and reinforce their professional reputation. A notary's ethical compass is as important as their legal knowledge. Avoiding unauthorized practice of law. The unauthorized practice of law, UPL, is a serious offense that notaries public must diligently avoid. Notaries are ministerial officers, meaning their duties are limited to witnessing signatures, administering oaths, and certifying copies, not providing legal advice or drafting legal documents. Offering opinions on the legality of a document, advising on the best type of document to use, or explaining the legal effect of a document constitutes UPL. This distinction is critical because only licensed attorneys are authorized to provide legal counsel. Notaries must always make it clear to clients that they are not attorneys and cannot offer legal advice. Crossing this line can lead to severe penalties, including fines, imprisonment, and revocation of commission. To avoid UPL, notaries should strictly limit their interactions to the Notarial Act itself. If a signer asks for legal advice, the notary should politely decline and recommend they consult with a licensed attorney. Notaries should never select the type of notarial certificate for a signer. The signer or the document preparer must specify the required act. Furthermore, notaries should not prepare or complete legal forms for others, unless specifically authorized by law to do so in a non-legal capacity. Maintaining a clear boundary between notarial duties and legal practice is paramount for protecting both the notary's commission and the public from potentially harmful misinformation. Continuous awareness of state-specific UPL guidelines is essential. Handling special notarial requests. Notaries may encounter special notarial requests that fall outside the most common acts, like acknowledgements and jurats. These can include notarizing documents for signers with disabilities, foreign language documents, or documents requiring specific handling due to their nature. When assisting signers with disabilities, notaries must make reasonable accommodations, such as reading the document aloud if the signer is visually impaired, or assisting with signing if the signer has a physical limitation, always ensuring the signer is willing and aware. However, the notary must never sign on behalf of the signer. Understanding state-specific guidelines for such situations is crucial to ensure compliance and accessibility for all individuals. Notarizing foreign language documents presents a unique challenge, as the notary is generally not required to understand the language of the document itself. The notary's duty remains to identify the signer and witness their signature, not to interpret or translate the document's content. However, the notarial certificate itself must always be in English. If the signer does not understand English, the notary must ensure that the notarial certificate is explained to them by a trusted, impartial third-party translator. Notaries must never act as translators themselves. For any unusual or complex requests, notaries should always consult their state's notary handbook or seek guidance from their commissioning authority to ensure proper procedure and avoid potential liability. Remote Online Notarization, RON. Overview. Remote Online Notarization, RON, allows notarial acts to be performed remotely using audiovisual technology over the Internet. This innovative method enables a notary and a signer to be in different physical locations while conducting a legally valid notarization. RON has gained significant traction due to its convenience and accessibility, especially in a rapidly digitizing world. However, not all states have authorized RON, and those that do have specific technological and procedural requirements. Notaries interested in performing RON must ensure their state permits it, and then complete any additional training or registration mandated by their commissioning authority. It represents a significant evolution in notarial practice, expanding access to services. The RON process typically involves robust identity verification methods, including credential analysis of the signer's ID and knowledge-based authentication, KBA. The entire notarial session is recorded, creating a secure audit trail. Notaries must use state-approved RON platforms that comply with strict security and data privacy standards. The notary's electronic signature and electronic seal are applied to the digital document. Understanding the specific technology, security protocols, and legal framework for RON in their state is paramount for notaries. This specialized area requires additional expertise and adherence to a distinct set of rules, ensuring the integrity and legality of remote notarial acts. Electronic notarization, e-notarization. Electronic notarization, or e-notarization, refers to the process of notarizing electronic documents using an electronic signature and electronic seal. Unlike remote online notarization, RON, e-notarization typically requires the signer and notary to be in the same physical location. The core difference lies in the format of the document and the tools used, which are entirely digital. Notaries performing e-notarization must use state-approved software and hardware that ensures the integrity and security of the electronic document and the notarial act. This method streamlines processes for businesses that primarily operate with digital records, reducing paper waste and increasing efficiency. It represents a modern adaptation of traditional notarization. The e-notarization process involves the notary applying their electronic signature and electronic seal to an electronic document. The notary must still verify the signer's identity in person, just as with traditional paper notarizations. The electronic signature and seal must be tamper-evident, meaning any alteration to the document after notarization would be detectable. Notaries must also maintain an electronic journal for all e-notarial acts, adhering to state-specific record-keeping requirements. Understanding the technological requirements, security protocols, and legal framework for e-notarization in their state is crucial. This specialized area demands additional training and adherence to a distinct set of rules, ensuring the integrity and legality of electronic notarial acts. Notary record-keeping and retention. Meticulous record-keeping is a fundamental duty for all notaries public, mandated by state law. The notary journal serves as the primary record, documenting every notarial act performed. Beyond the journal, notaries may also be required to keep copies of certain documents or notarial certificates. These records provide a crucial audit trail, protecting both the notary and the public in case of disputes or legal challenges. State laws specify the required retention period for notary records, which can range from several years to the entire duration of the notary's commission, plus additional years. Adhering to these retention schedules is not optional. It is a legal obligation that ensures accountability and transparency. Notaries must ensure the security and confidentiality of all their records, whether physical journals or electronic logs. Physical journals should be stored in a locked, secure location, inaccessible to unauthorized individuals. Electronic records must be protected with strong passwords, encryption, and regular backups to prevent data loss or unauthorized access. Upon the resignation, expiration, or death of a notary, state laws typically dictate how the notary's records must be handled. This often involves depositing the journal and other records with the commissioning authority or a designated county official. Proper record keeping and retention are essential for maintaining compliance, defending against liability, and upholding the integrity of the notary profession. Notary liability and penalties. Notaries public hold a position of public trust, and with that trust comes significant liability. Notaries can be held personally liable for damages resulting from their errors, omissions, or intentional misconduct. This liability can arise from negligence, such as failing to properly identify a signer, or from intentional acts such as notarizing a forged document. The notary bond protects the public, but the notary themselves is ultimately responsible for their actions. Understanding the potential for civil liability is crucial for every notary, as mistakes can lead to substantial financial penalties and legal battles. Diligence and strict adherence to state laws are the best defenses against such claims. Beyond civil liability, notaries can also face administrative penalties from their commissioning authority and, in severe cases, criminal charges. Administrative penalties can include fines, suspension of the notary commission, or permanent revocation. Criminal charges may be brought for acts like fraud, forgery, or the unauthorized practice of law, leading to imprisonment. The severity of penalties depends on the nature and impact of the misconduct, as well as state statutes. Notaries must be acutely aware of the serious consequences of failing to perform their duties correctly and ethically. Continuous education and a commitment to best practices are essential to mitigate these risks and protect one's commission and reputation. Reporting notary misconduct. Maintaining the integrity of the notary public system relies on the ability to report and address notary misconduct. If a member of the public or another notary witnesses or suspects a notary has violated state law or engaged in unethical behavior, it is their civic duty to report it. Most states have a clear process for filing a complaint against a notary public, typically through the Secretary of State's office or the commissioning authority. These reports are taken seriously and can trigger investigations into the notary's conduct. Reporting misconduct helps to protect the public from fraudulent or negligent notarial acts and upholds the professional standards of the notary community. When reporting misconduct, it is important to provide as much specific detail as possible, including the date, time, location, and nature of the alleged violation. Any supporting documentation, such as copies of notarized documents or communication records, should also be included. The reporting process is usually confidential to protect the complainant. Notaries who are found to have engaged in misconduct can face administrative penalties, civil liability, and even criminal charges, depending on the severity of their actions. Understanding how to report misconduct and the importance of doing so is vital for ensuring accountability and preserving public trust in the notary profession. It reinforces the system's checks and balances. Notary public resignation/expiration. A notary public's commission is not indefinite. It has a specific expiration date, typically ranging from 4 to 10 years, depending on the state. It is the notary's responsibility to be aware of their commission expiration date and to plan accordingly for renewal or resignation. If a notary chooses not to renew their commission, or if they move out of state, they must formally resign. The resignation process usually involves notifying the commissioning authority in writing and following specific instructions for handling their notary seal and journal. Failure to properly resign can lead to administrative issues or continued liability. This formal closure ensures a clear end to the notary's official duties. Upon resignation or expiration of a commission, state laws dictate the proper disposition of the notary's official seal and journal. In many states, the notary is required to destroy their seal to prevent any unauthorized use. The notary journal, which contains sensitive personal information, must typically be surrendered to the commissioning authority or a designated county official for secure storage. Notaries should never simply discard their journal or seal. Adhering to these procedures is crucial for maintaining compliance and preventing potential fraud or misuse of notary tools and records. Understanding these end-of-commission requirements is as important as understanding the initial commissioning process. Renewing your notary commission. For notaries who wish to continue their service, renewing their commission is a necessary process that typically mirrors the initial application. States usually require notaries to apply for renewal before their current commission expires, often with a specific window for submission. The renewal process often involves submitting a new application, paying a fee, and potentially completing updated training or passing another examination. This ensures that notaries remain current with any changes in state notary law and continue to meet all eligibility requirements. Proactive planning for renewal is essential to avoid any lapse in commissioning, which would prevent the notary from performing official acts. It is crucial for notaries to be aware of their state-specific renewal deadlines and requirements. Some states offer a grace period, while others require a completely new application if the commission lapses. Notaries should also ensure their bond and E&O insurance, if applicable, are current and will extend through their new commission term. Any changes in personal information, such as name or address, must be updated with the commissioning authority during the renewal process. Staying informed and organized is key to a smooth renewal, allowing notaries to seamlessly continue their important public service without interruption. Timely renewal reflects professionalism and dedication. Building a notary business, transitioning from a commissioned notary to a successful notary business owner, requires strategic planning and entrepreneurial spirit. This involves identifying your target market, whether it's real estate, legal firms, or the general public, and tailoring your services accordingly. Developing a strong business plan that outlines your service offerings, pricing structure, marketing strategies, and financial projections is crucial. Consider specializing in niche areas like loan signings or remote online notarization to differentiate your services. Building a notary business is about more than just performing notarial acts. It's about creating a sustainable and profitable enterprise that meets client needs effectively. Professionalism and reliability are key differentiators in a competitive market. Effective marketing and networking are essential for attracting clients. Create a professional online presence, including a website and social media profiles, clearly outlining your services, availability, and contact information. Join professional notary associations and local business groups to network with potential clients and referral sources. Consider offering mobile notary services for added convenience, which can be a significant advantage. Continuously seek feedback from clients to improve your services and build a strong reputation. Remember that your notary business is built on trust and integrity, so consistently delivering excellent service will foster client loyalty and generate positive word-of-mouth referrals. Strategic growth and client satisfaction are paramount. Continuing education for notaries. The legal landscape governing notary publics is dynamic, with state laws and regulations subject to change. Therefore, continuing education is not merely beneficial but often a mandatory requirement for notaries to maintain their commission and stay compliant. Many states require notaries to complete a certain number of continuing education hours or pass an updated exam before renewing their commission. This ensures that notaries are always informed about the latest statutory changes, best practices, and technological advancements, such as remote online notarization. Investing in ongoing education protects the notary from inadvertent errors and enhances their professional competence, reinforcing their value to the public. Beyond mandatory requirements, proactive engagement in continuing education demonstrates a notary's commitment to excellence and professional development. This can include attending workshops, webinars, or conferences focused on notary law, ethics, and specialized notarial acts. Subscribing to Notary Association newsletters and regularly reviewing updates from the Secretary of State's office are also vital. Staying informed about emerging trends and technologies in the notarization field, such as new e-notarization platforms, allows notaries to expand their service offerings and remain competitive. Continuous learning is a hallmark of a truly professional notary, ensuring they are always equipped to perform their duties accurately and ethically.